Can you start off just explaining the significance of a bail hearing and how far along in evidence collection we are at this point?
Yeah, so basically, the purpose of bail is that we have somebody who's been arrested and charged with a crime, but they haven't been convicted yet. So, what do we do? Do we just lock them up, or since they're presumed innocent until proven guilty, should they not be locked up? The challenge that the system has is that somebody who's faced with potential imprisonment may just flee. And so, how do you ensure that the person will show up for trial, comply with any conditions of, not harming other people and so on? So, the idea of bail is that there's an amount that will matter enough to the person that they'll lose if they flee the jurisdiction. But if they show up for the trial, they'll get that bail back. So that's basically the purpose of it. So usually you would look at things like what sort of ties the person has to the community. The more ties they have, the less likely they are to flee. Um, the nature of the charges against them. If it's a low-level charge, you're probably not going to flee for something where, you wouldn't even get any prison time. But if it's a life sentence, that's going to be a heavier incentive to flee the jurisdiction. Those will go in, the calculations will go into the judge in determining how much to set the bail at. And then there may be instances when the government will argue that no amount of bail will ensure that this person will show for trial and guarantee the safety of the community.
How far along in the evidence collection process are we at the time of a bail hearing?
Well, typically, the indictment would have been issued. That's what would allow the ability to impose bail and or hold somebody without bail pending trial. So, indictment means the government needs to have at least probable cause, which is actually the same standard for arresting, but that's sort of the minimum. I mean, I think as a matter of practice, the prosecutors would have far more than just bare probable cause to get in before they get an indictment. Does that mean that they're completely finished with the investigation? Not necessarily. They could feel they have more than enough to get the indictment, but still continue to do some little more investigating here and there.
When we look at these documents and the arguments filed before the bail hearing, does that give us any indication of specifically maybe how the defense lawyers plan to argue this case in a trial?
Um, I think so. When you watch the law shows, because fiction is very much a dramatic form, and so papers are not dramatic, but lawyers arguing in front of the judge is dramatic. But in my experience of having been a law clerk for judges, the vast majority of the time, the judges have decided based on the briefs that have been filed. And it's a small percentage of cases where the oral argument will make a difference. The trick is you don't know if you're in that small percentage, so you have to like give it your all.
In this specific case, according to the U.S. Attorney's Office, there's not any video evidence. There was no surveillance cameras and there's no body cameras on these officers. How much do you think that could contribute at trial, the lack of video evidence?
Uh, so there's an analogous situation, not video, but DNA evidence around the beginning of the 21st century, where prosecutors started losing some cases that they sort of in the past had been winning. And it turned out that the theory that was coined for this was called the CSI effect, that because of the popularity of that show, CSI, that jurors actually started to expect that there would be DNA evidence in every case. And when there wasn't DNA evidence, then they would think, well, there must be reasonable doubt. So could something like that happen in this case now where body cam footage is fairly routine? And if there's not body cam footage, would jurors be more skeptical? It's possible. I will say that looking at the government's arrest affidavit, where they have the pictures of the damage to the vehicles. Now, maybe this is all fabricated, but assuming that that's really what happened to the vehicles, that's I think some pretty good evidence of the amount of force that was used to hit the vehicle. So I don't know. I think it would be a something the government would probably have to overcome, but I don't think it would be insurmountable.
You mentioned that arrest affidavit. It did not include an interview with the agent who fired a shot. Do you have any idea why that interview may have not been in the arrest affidavit?
I don't know specifically the ICE agents, if they're even unionized and what sort of rules there are. But I know for Portland Police Bureau, there was this long-standing issue about if there was an officer-involved shooting, when the officer would be interviewed and when the officer would be able to look at any video evidence, either before or after making the statement. And so I don't know if with the ICE agent, if the agency just has to have some rule where they have to wait some amount of time before they interview somebody who's in the officer involved shooting.
Last question. In the argument before the bail hearing, the defense makes a big deal about the fact that the U.S. attorneys don't have evidence to show intent on behalf of this defendant, and that they say he was scared and tried to flee, but they can't show that he intended to assault these officers. What do prosecutors need to show when it comes to intent for a charge like this? Do they need to show intent at all?
Can you remind me specifically what the charge is?
The charge is assaulting a federal officer. The
Okay,
defense attorneys are saying you're not able to show that he intended to assault them. He was scared and was trying to
right.
get out.
Got it. Okay, so assault is so most crimes have what we call a mens rea element, which is the mental state. You have to have the physical act and the mental state. So just as an example, if somebody punches you, that would be assault or battery. Now, the physical action is that you got hit, and then the mental state, the mens rea is, well, normally the natural consequence of throwing a punch at somebody is you'll hit them. But let's say that you got hit not because somebody threw a punch at you, but because they were stumbling and they just sort of stuck their arm out and their hand just happened to hit you in the face. Now, there's still a physical act. You got hit in the head, but there we would say that, well, that's an accident. They didn't have the intent. They did not mean to hit you in the face, and so that would not be assault. So in this case, the defense argument would be the hitting of the vehicles, and I guess one of the officer was brushed or whatever. That's the physical act, but you have to correlate that with the mental state, and so you have to show that the purpose of it was to drive the vehicle into the officer. Now, instead, if the guy, again, let's say that he was trying to back up and he accidentally put the car in drive instead of reverse. Uh, how would we know this? We have to read minds or whatever. But let's say we knew that were the case, then it would not be assault because it would be an accident.
Got it. So intent does play a role when you're trying to prove a crime.
Yes. Well, so basically, every crime will have what we call elements of the crime. And these are the things that the government will have to prove every element beyond a reasonable doubt. And the judge will give jury instructions to the jury. And so, in the case of assault, I don't teach this class, so I don't know the elements off the top of my head, but it would be some unwanted touching plus the intent. There are different mental states. Some of them are intent, which is you have the purpose of it. Others are knowingly that you just knew this would happen. You didn't necessarily have to have the intent, but you knew it would happen. Others are slightly lower, like recklessly. When you go to law school and you take criminal law one, you'll get all of these. But so you basically have to look at the crime. The crime will tell you what mental state has to be proven, and intent is one of the mental states that's used for these crimes.
Tung, thank you so much. Is there anything else on this you think is important for viewers to understand?
Um, so I think I remember, is the defendant undocumented or is he documented?
Yes,
Okay.
undocumented.
So, I mean, I imagine that's got to be a big part of the government's case about the likelihood of fleeing and so on. So they'll
Yeah.
probably make a big deal out of that.
Okay. All right, we'll
Okay.
keep in touch. Thank you so much, as always.
Okay. All right.